Okay, hello everyone, and welcome to Fairfield County's live webinar on the new Corporate Transparency Act, what you need to know and do. I'm Bob Hogan, the webinar coordinator and a business mentor here at SCORE Fairfield County. I'm going to be your host today, and our presenter is Cliff Ennico. More on Cliff in just a minute, and first some brief information on SCORE. SCORE is a nonprofit national partner of the SBA with over 10,000 volunteers nationally. And locally here at SCORE Fairfield County, we have over 100 volunteers with a wide range of industry, process, and subject matter expertise. And we offer three primary value-added services to small business owners. First of all, we offer one-to-one business mentoring, and you can access that in any way that is convenient to you, by telephone, by Zoom, by in person, by email, whatever works for you. Secondly, we offer a wide range of business education programs like the one today, roughly over 100 throughout the year. And lastly, we offer extensive resources on our website, including access to subject matter experts. Our next live webinar will be tomorrow, March 27th at noon, and the topic is Positioning Your Business for Government Contracting with Tanisha Baptiste and Shelley Arose presenting. Again, more specifics on our website, fairfieldcounty.score.org. And if you're on our website, you can also access a wide range of recorded webinars on demand at any time. Just go to our website, click on workshops, and then click on demand webinars. Just some logistics about today's event. We have set aside time for Q&A at the end of the presentation. So if you have a question, please use the Q&A button at the bottom of your screen, and we'll take as many as we can before the top of the hour. Our webinar will end sharply to respect your time. The session is being recorded, and a link to the recording will be available on our website within the next day or so. The slides will not be distributed, but again, you can access the recording. Now, my pleasure to introduce our speaker, Cliff Ennico. Cliff is a nationally recognized authority on small business, legal, and tax issues, and is best known as the former host of Money Hunt, the PBS television series for entrepreneurs. He is the author of 16 books, including the Crowdfunding Handbook, Raise Money for Your Small Business, or Start Up with Equity Funding Portals. Cliff judges business plans and elevator pitch competitions nationwide, and as an attorney and small business consultant based in Fairfield, Connecticut, Cliff has helped launch thousands of businesses in his 43-year career. I'll now turn it over to Cliff. Cliff, it's all yours.
Hey, thanks, Bob, and welcome to everybody. Thanks to all of you for taking a part of your busy day out from your running your business to oh, there we go. Okay, any questions? Now we just went through the entire presentation there. So any questions? Thank you for spending part of your day with an attorney, which you can see this is what I am. I have been practicing in Fairfield. I've been practicing law for 44 years of my life. Yes, there were no child labor laws back then. I am something of a prodigy. But this is a topic that we're going to be talking about today. Is a very urgent topic. It's something that a lot of people are wrestling with right now, and unfortunately, there's a lot of incorrect information on the web right now about this. So I'm kind of hoping I can cut through some of that and also make this a little simple for people. I mean, this is a legal thing, and you shouldn't have to go running to a lawyer every time you go to a bathroom. This is actually something you probably can do yourself. Most of you probably can. So without any further ado, let's move on. What is this Corporate Transparency Act? This is a federal statute, a federal law. It was passed back in 2021, but they buried it. They didn't. This isn't. If you search online for, if you search the Federal Register for Corporate Transparency Act, you're going to have a hard time finding it, because what they did was, rather than pass it as a standalone statute, they attached it as part of the Defense Appropriations Bill of 2021. It's like page 600 of that document. And oh, by the way, there's this little statute here where we're going to make everybody register with the federal government, their small businesses. I mean, just it was buried in there. So a lot of people didn't really even become aware of it until January 1, which is when the law went into effect. The goal is an honorable one. What the federal government is trying to do here is that they're trying to build a database of small business entities that are likely to be used by people who engage in financial crimes like money laundering. The people that do these kinds of nefarious things very often hide behind sham or shell companies that are often set up as LLCs, corporations and other legitimate small businesses. Basically, what the law requires is that every small business in the United States that is organized as a corporation, LLC, or limited partnership, we'll talk about more in a minute who has to comply with this. But if you have a small business that is organized as a corporation, LLC, limited partnership, if you had to file a piece of paper with the Secretary of State's office in Connecticut or New York to set up your business, you have to comply with this. Plain English, no matter how small you are, even if you're just a one-person LLC, you have to comply with this. Now, what happens when you do? Well, right now, the way the law is drafted, the information can only be disclosed to the federal and state law enforcement agencies. This is not going to be a public database that people can access. You will not be able to go to the federal government website and find out who owns and whatever LLC. That is not happening, at least not yet. Now, of course, like any law, it can be amended. And once the database has been established, and once everybody is logging into it every year, that may change, just like any law is for. So that is what we are talking about today. Is it constitutional? The short answer is maybe, probably yes. Some of you may know that there was a case brought in Alabama earlier this year to challenge it. The federal district court in Alabama basically said that it did not say that the statute was constitutional. It did strike down the statute, but only for members of the organization that had brought the lawsuit, something called the National Small Business Alliance. The NSBA had brought an argument based on the fact that, hey, wait a minute, only the states can form corporations. The federal government doesn't get involved in the process of incorporating small businesses and shouldn't be doing that. The court didn't really address that issue. It just simply said that as to members of that organization, the statute does not apply, but it did not strike down the statute on constitutional grounds. So for now, at least, resistance is futile. There may be other constitutional challenges down the road. I wouldn't be surprised. There are some states like Nevada and Delaware that offer corporations and LLCs a certain amount of secrecy. You can't go to the Delaware Secretary of State's office and find out who owns XYZ Inc. All you can find out is the name of the company and their registered agent. That practice is now going to be challenged somewhat by the Corporate Transparency Act and what it requires you to do. So who needs to comply with this silly thing here? This new thing here. Basically, all small businesses that are organized as corporations, including S corps, limited liability companies, limited partnerships, limited liability partnerships, LLPs, a lot of professional service firms, lawyers, architects, accountants use the LLP format. The act refers to these as reporting companies. Basically, if you had to file a piece of paper with the Secretary of State's office in Connecticut or the Department of State in Albany, for New York people who are on this call, if you had to do that, you have to comply. If you did not have to do that, you did not have to comply. So sole proprietorships, people like me, for example, Cliff Ennico doing business as law offices of Clifford R. Ennico, Joe Blow doing business as Joe's Antiques. If that is all you are, is a Schedule C filer, you never had to file a piece of paper with a government agency to form your business, you just file Schedule C every year, you do not have to comply. Likewise, general partnerships, small partnerships, a husband and wife are in business together, they file a Schedule C or they file a 1065. General partnerships do not have to register with the state government at all when they form. You can form a general partnership with a handshake. You don't even need a written agreement, although it's a silly thing to do not to have one. But so general partnerships, sole proprietors do not have to comply with the law. Everybody else basically does, with some exceptions, though. There is no small business exception. That's the thing you need to know here. Even a one-person LLC, engaged in a consulting business, working out of their spare bedroom, like I do, has to comply with this and file the ownership report. And we'll talk about exactly what you have to do in a minute. There are 23 exemptions. Most of them do not apply to you. Most of them apply to certain businesses that are registered with the federal securities or banking authorities. So if you are a bank or a venture capital firm or a broker dealer that is registered by the SEC, or any of the federal banking authorities, there's several of them. You do not have to register with FinCEN. The government already has the information that FinCEN wants, so it doesn't. It would be it would be redundant to have these companies apply. Tax exempt entities are not required to apply. So if you are a 501c3, for example, and you have a 501c3 exemption from the federal government, you applied on Form 1023 or 1023-EZ, and you actually got a determination letter saying that you are a tax exempt organization, you are not required to comply with the Corporate Transparency Act. If you have a nonprofit and your application is pending for 501c3 status, you want to watch the deadlines, because if you don't get your 501c3 approval by the end of this year, you may be required to comply with that. So nonprofit entities are kind of in a holding pattern at this point, but most of them, if you have your determination letter, you don't have to do anything. Large operating companies are also exempt. These are companies with more than 20 full-time employees, and you have to file a tax return showing more than $5 million in gross sales and gross receipts. So if you have more than 20 full-time employees and you filed a tax return showing $2 million in gross sales or receipts, you may have to comply with the Corporate Transparency Act. That's an and, not an or. You have to have, in order to be exempt from the tax requirements, you have to have more than 20 full-time employees and filed a tax return showing more than $5 million in gross revenue, gross sales, and gross receipts. Inactive entities. This is probably the most controversial exception. It's the very last one of the 23. Basically, the fact that you haven't done anything in a while does not make you an inactive entity. There's a very strict definition. Inactive entities are companies that were in existence before January 1 of 2020. The not engaged in active business, don't have any assets, no change in ownership in the previous 12-month period, has not sent or received funds from a bank account for more than $1,000 in the preceding 12-month period. The entity is not owned by a foreign person. Basically, if you meet all these requirements, you're dead. There is no two ways about it. Chances are the state that you are incorporated in probably has dissolved you already, because you haven't been filing your annual reports, you haven't been filing tax returns, you haven't been doing all the things you need to do to keep a corporation or LLC alive. So you're probably dead already. You just don't know it yet. But the thing is, though, if you don't meet these requirements, so let's say, for example, that you have a business that you haven't been using for a year. It's just an LLC that you registered. You're thinking about using it someday, but you haven't done anything with it in the last couple of years, and you are filing tax returns each year, showing 0, revenue, 0 assets. You may not be an inactive company. You may have to comply with the Corporate Transparency Act. If that is the situation you find yourself in, you should seriously consider dissolving your company this year. And so that way you don't have to, I mean, it's not completely clear from the act, but most attorneys are taking the position that if you have a company that you dissolve this year, you will not be required to comply with the Corporate Transparency Act and file the beneficial ownership report with FinCEN. You probably will not have to do that. I mean, if your company's dead, there's really nothing more to see here. So most attorneys are taking that position. The act doesn't specifically say that. You know, technically, if you had a corporation in January and February, and you dissolved it during the month of March, technically you are still subject to the act. But I can't imagine that FinCEN is going to go after a company that formally dissolved during the period, during the compliance period. So that's the whole thing about who has to comply. Now, when must you comply? So let's say you are a reporting company. You are a company now that is required to comply with the act. The deadlines are very clear. For companies formed after January 1 of this year, you have 90 days after the date of formation. So if you formed a company on January 1, that deadline is March 31st of this year. Coming up very soon after this webinar. 90 days. after the deadline. After January 1 of next year, that deadline is going to be reduced to 30 days. What the government wants here is they want this FinCEN registration to be part of the incorporation process. They want attorneys and accountants and other people who form companies for a living like me to make sure that the FinCEN application is part of the original incorporation process. And they want to get to that. They're giving people 90 days to do it this year because they figure a lot of people are not aware of the act, but by next year they expect everybody to be aware of the act. That's why they did it this way. For all other companies, if you're formed before January 1 of 2024, you have until January 1 of next year to file your report. Okay, so they're giving you this hire this year. So if you have a company that you haven't been using for a while that's somewhat inactive, a question you should ask your accountant or attorney is, does it make sense to dissolve it this year, or should I just file the report and keep this thing on inactive status? As I say, the definition of inactive company is really tight. Just the fact that you haven't used a company in a while does not necessarily make you an inactive entity. What happens if you miss the deadline? What happens if you blow it? Well, there are numerous penalties, which I will talk about later on in this program. Um, but the bottom line here is that that what happens if you miss the deadline? I mean, the question that some of you are going to be asking yourself, um, you are, how are they going to find you? I mean, that's a question that, a lot of people are asking. Obviously, no attorney or accountant will ever say, oh, don't just blow this thing off because they're never going to find you in a million years. You're not on their radar screen. No one is ever going to say that. The penalties are very severe, $500 a day for each day that you are late filing this, filing the necessary report. Um, it's not something that they would do. I mean, the bottom line is the penalties are very severe. So if it's something that's going to keep you awake at nights and you have a company, like I say, that's sort of, that you don't really use all that much or that you're not taking seriously, better to dissolve it and not have to worry, and in a situation like that, I think most attorneys and accountants will say that if you dissolve your company this year, they're probably not going to come after you for not filing your beneficial ownership report. But again, no guarantees of that, but I would say it's highly unlikely. If you have a company that you're not using all that much and this is going to bother you, dissolve it and do it the right way. Dissolve it with the Secretary of State's office. Okay, so what does the act require you to do? Okay, if you are a reporting company, if you are subject to the act's requirements, you must file a beneficial ownership information record. I'm just going to call it a BOI, B-O-I, with FinCEN before the deadline. FinCEN is the Financial Crimes Enforcement Network. It's part of the U.S. Treasury, the same people that run the IRS. Basically, it's the part of the organization of the federal government that prosecutes financial crimes such as money laundering and that kind of thing. It's an electronic filing. You cannot file paperwork. You file it electronically. Basically, the purpose of the Corporate Transparency Act is to create a database of all the individuals, and this is important, the individuals that run a certain company. So if I'm doing business as Cliff Ennico LLC, they want a database saying that Cliff Ennico is the guy behind Cliff Ennico LLC. It's a database that has only one purpose: to show the individuals that run a specific company. That is it. It pierces the corporate veil and goes right to the individuals. That's the thing. So in theory, if I'm a law enforcement agency and I want to find out, all the companies that Donald Trump, or pick your favorite politician, has his fingers in and owns a piece of, or any celebrity, Hollywood celebrity, I can go into this database and I can find out who those people are that run this company. Who are the people pulling the strings behind the puppet? That is what they want here. It's an electronic filing. There's the link where you go online if you're going to do it yourself. The site does allow you to download the form as a PDF, fill it in, and file it later. If you're nervous about doing this for the first time, that's probably what I would recommend you do. Although I will say that the software, I've done about 40 of these now for my clients, and the software is fairly user-friendly. It's fairly intuitive. They really do want to make this easy for people to comply. And I was actually surprised at how easy it was to do the first couple. Basically, if you're going to do it yourself, what you need to do is you need to pull together some information. You need, first of all, for your company, the name, the mailing address that it uses, and this should tie into the Secretary of State's records. So for example, if you work out of your home, but you're using like a UPS store private mailbox, and that's the business address that appears in the Secretary of State's office, I would use the UPS store private mailbox address. And you also need your federal tax ID number, your EIN for the business. All very straightforward stuff. Now, for each beneficial owner who has to be disclosed, and we'll talk to you, we're going to talk a lot about that. Who is a beneficial owner? Who has to be disclosed and who can be left off? You need very specific information. You need the name, their mailing address, their date of birth, and a photocopy of their driver's license or U.S. passport. By the way, I apologize. I should have added that to this slide. If you're doing the driver's license, you only need to photograph the front only. And if you're doing the passport, you only have to do the photo page. You don't have to do all the pages with the visas on it, just the one with the photo on it. That has the information that the government wants. The photo must be in JPEG or PDF format. Very important. If you take a cell phone of your driver's license, that is something called a PNG file, and the government cannot accept that. They have to have it in either JPEG or PDF. Although once you do the cell phone photo, when you upload it to your computer, you should be able to save it as a JPEG or a PDF format, and that will work. The government will accept it as long as it's not too fuzzy. As long as they can still make out your features, it should be acceptable. But that's one little hiccup that I had. A lot of my clients took cell phone photos of their thing, and the government would not accept that. It bounced that. So that's the one technological thing you have to know about when you do this filing. Interestingly, what I find very interesting as a lawyer is what FinCEN does not require as part of the filing. They don't require the date of business formation. So some of you are asking yourself, wait a minute, Cliff, how does the government know? If I file a thing saying that I was formed before January 1st, but I really was formed later, how are they going to know about that? Well, sooner or later, they probably will check the Secretary of State's records and see if everything, matches up. But right now, they're not asking for that information. So how would they know? For example, this is a question a client of mine actually asked me the other day, Cliff, what if I missed that 90-day deadline? Can I file later on and say that I was formed prior to January 1? How are they going to know any different? That's a very good question. Of course, no attorney is ever going to say that you should play games with this. No, I mean, if you were formed after January 1, you should file within the 90-day period. If you're a day or two late, I mean, who knows? They may not be very strict about enforcing the $500 a day, but they don't request the date of business formation, which I find very odd. Given the fact that they have these very strict deadlines for filing. The second thing they don't require is the Social Security number of the beneficial owners. I mean, to me, that would be a very key piece of information. They don't ask for that. I mean, maybe it's because when they have the EIN, every EIN has a responsible person, and so the IRS already has your Social Security number. If you obtained an EIN for your small business, the government already has your Social Security number. So maybe that's the reason they didn't ask for the social. But for other beneficial owners who were not the responsible person designated when the company was formed, I mean, again, there are some interesting omissions here, and the only thing that I can think about is that they really are trying to make this simple as possible, and that they will add these requirements later on once this becomes part of everybody's radar screen. Once this statute is now on everybody's radar screen. So what do you disclose? Okay, well, basically, you have to disclose information about the beneficial owners of your business, and that's a technical defined term in the statute. A beneficial owner is someone who either substantially controls the business operations, owns 25% or more of the stock, the equity in the company, or both of the above. It's either or both. Okay. Anyone, again, the primary goal of this statute is to identify the individuals behind LLCs, corporations, and other business entities. And it's the individuals they're looking at. They are not looking for other companies. They're looking specifically to find out, hey, we've got this LLC here. Who is the genius? Who is the gray eminence that's running this thing, that's responsible for it? And they have two definitions. Anyone who owns, let's take the easy one first. Anyone who owns 25% or more of the equity, securities, or ownership interests in the business is a beneficial owner who has to be disclosed. So if you're in business with your spouse and you're 50-50 and you have an LLC, each one of you is a beneficial owner of the company and has to be disclosed. That's the simplest one that I can think of. But the statute also picks up people who substantially control the business operations. And the simplest example I can think of here is a managed LLC. Let's say that you have an LLC with a bunch of owners, but you have a professional manager who runs the business, and that manager is not one of the members. They don't own any piece, although they may have some options to acquire equity in the future. That manager is a beneficial owner because he substantially controls the day-to-day operation of the business. Even though he doesn't own any equity, he or she doesn't own any equity in the company, the fact that they are running the show makes them a beneficial owner for purposes of the act, and that person needs to be disclosed. So let's use some examples. You should be aware, by the way, there is a federal statute that says that whenever you use any kind of an example of a company with multiple owners, you must refer to the Three Stooges. Okay, this is I'm teasing about that, of course. I like to use the Three Stooges because it's very clear, I want to be very clear here because some of this stuff can get a little complicated about who's a beneficial owner. So let's say Mo and Larry own an S corp. And by the way, S corps are corporations. They have to comply under the act. Mo owns 90% of the shares. He's the sole officer and director of the company. Larry owns 10%, but he is not an officer or director. He's a passive owner. He's an investor in the company. He's Mo's buddy and is helping him out with some money. Mo is a beneficial owner of the company, both because he owns more than 25% of the shares and he substantially controls the operation of the business. He's a director and an officer. Larry would not need to be disclosed. He doesn't have 25% and he's not actively involved in the operation of the business. Okay. Now let's use another example, a little bit more complicated here. Mo, Larry, and Curly own an LLC. They're 1/3 each. But Mo and Shemp, the fourth stooge, are the LLC managers. Larry and Curly are passive owners and they are not involved in the operation of the business. Now, Mo, Larry, and Curly are beneficial owners because they each own more than 25% of the company. Shemp is a beneficial owner also because as a manager, he substantially controls the operation of the business. So in this example, all four stooges would need to be disclosed as beneficial owners. Again, the thing to keep in mind here is that it's either or. Either that you own 25% or more, or you substantially control the company, or both. That's the important thing. Someone who substantially controls the company's operations, but it only has 10% of the equity in the company, is a beneficial owner and is required to be disclosed. So for example, now the question you're going to ask me, and some of my clients already have, let's say you have a deal where you have, Mo, Larry, and Curly own 1/3 each, but you have a provision in your shareholders agreement, which says that basically for certain types of corporate action, 100% of the LLC members must agree or approve. You need unanimous consent. And let's say you have a 10% owner of a company that has a shareholders agreement like that or an operating agreement like that. In that situation, which is not a great idea to begin with, you don't want to give a 10% person that much power over the company's operation. I would take the position that 10% owner is a beneficial owner because of that veto provision. That person can veto certain corporate decisions, and that veto power makes him a beneficial owner for purposes of the corporate. Now, that may be too conservative. Some other attorneys maybe take a more relaxed position on that. But again, the definition of substantial owner control is very, very broad under the Act. Okay, so now what happens? So that's the simplest example. Now let's take some more complicated examples. If your business is owned by another company, what happens if you have a stack of corporate ownerships. I work with a lot of people who do real estate development. They usually have a holding company at the top that's owned by a bunch of investors, and then they have separate LLCs for each one of their 30, 40 properties that are 100% owned by the holding company. It's a very common structure for real estate developers, people who develop, residential or commercial properties. In a situation like that, by the way, all 30 companies have to file beneficial ownership reports with the FinCEN. So basically, if your business is owned by another company, each company in the daisy chain needs to file a separate beneficial ownership report, a BOI, reporting its beneficial owners, the individuals that ultimately own and control the company. A beneficial owner under the act must be an individual. It cannot be another company. So let's use some examples. Corporation A is owned by LLC B, that in turn is owned by Mo, Larry, and Curly, one third each. I'm going to keep the ownership simple on this one. Corporation A and LLC B would each have to file a BOI showing Mo, Larry, and Curly as their beneficial owners. So Corporation A would file a BOI showing Mo, Larry, and Curly. LLCB would file a separate BOI showing Mo, Larry, and Curly. The companies are separate. The ownership is the same, but each company has to file a separate BOI. Okay, hopefully that is clear. Companies that have common ownership. So for example, in my real estate example before, where you have a holding company and 15 LLCs for the individual properties, all 16 of those companies would have to file BOIs showing the same people as beneficial owners. Pain in the ass, and it's going to take you a while to do this. The software, the FinCEN software does allow you to create an identification number for beneficial owners, and that's a situation where I might recommend that you do that, because that way you don't have to type in all the same information 16 times. You can, when you do the first one, you can assign each of the owners a FinCEN identification number, and then just use the numbers each of the subsequent 15 filings. I'm going to make a fortune doing these. I gotta tell you that. It's time consuming as hell when you have multiple company ownership and you have to do a separate BOI for each one. Okay, let's take a more complicated example now. LLC A is owned 90% by Corporation B and 10% by Mo, who is a passive owner. He's not involved in running the business. So the LLC is owned 90% by the corporation, 10% by Mo. Now, Corporation B is owned by Larry, Curly, and Shemp, 1/3 each. Okay, so we have 4 potential beneficial owners, but who actually has to be disclosed? LLC A and Corporation B would each file a BOI showing Larry, Curly, and Shemp as the beneficial owners. The corporation owns 90%. So 30% of 90%. I'm sorry, 33% of 90% is 30%. So we're above the 25% threshold for Larry, Curly, and Shemp. They would have to be disclosed. Mo would not need to be disclosed as a beneficial ownership of either company. He doesn't own anything in Corporation B, and he only owns 10% of LLCA. So he would not have to be disclosed. Now, a conservative attorney might tell you to disclose Mo anyway, because he obviously is part of the ownership and management team, and maybe there's an argument that he substantially controls the activities of LLCA. That would certainly be the case if he was the sole employee of that company and was running the business for Corporation B. Then he might be considered a beneficial owner on the substantial control definition. He might be. A conservative attorney might take that position, and they would not be wrong in that. Okay, let's go to our next example here. Mo owns 100% of LLCA, which in turn owns 100% of 5 LLCs. This is exactly my real estate developer example. All 6 companies would have to file a BOI showing Mo as the sole beneficial owner. Pain in the ass. Like I said, the software gives you the chance, when you do up the filing, you can create an identification number for a beneficial owner. You fill out all the information and then assign that person an ID number, and then you can use that ID number over and over again, so you don't have to type in all the information on all the subsequent filings. Okay, so what you must disclose um, here. Okay, now we have to talk about probably the most complicated part of the Corporate Transparency Act. If your company was formed on or after January 1 of this year, this does not apply to older companies. In addition to disclosing the beneficial owners of the company, you must disclose information about company applicants. Company applicants, and this is the Act's term, are the individuals who basically are responsible for setting up the company. So if your accountant or lawyer set up the company and the company was formed after January 1, that person would be your company applicant. So, for example, if I form your company and I'm doing the FinCEN registration, I have to name myself as a company applicant. And I do have a FinCEN identification number, so I don't have to type in all my information, each time I do this. The information is the same as it is for a beneficial owner. You still got to disclose what the name, mailing address, date of birth, and driver's license or U.S. passport. Oh, by the way, what if somebody is overseas? What if you have a beneficial owner that is overseas, that is not a U.S. citizen or a U.S. resident? FinCEN will accept a photocopy of their foreign passport. That's the most common thing. There's other documents that they will accept that are much rarer. But if you've got a foreign investor who's traveling to the US, he probably has a passport under his home country, and that a photocopy of that page would be acceptable. I'm surprised that nobody raised that question, actually, because again, I mean, one of the things they're looking for Al Qaeda and ISIS people who probably are not U.S. citizens. So that's again, foreign people are not exempt from this requirement. Okay, so let's go back to the company applicant thing here. So if your lawyer or accountant, basically, if they sign the certificate of incorporation or the LLC articles of as the incorporator or organizer, that's your company applicant, and that is the person that needs to be disclosed. Now, if you signed as incorporator or organizer, but your lawyer accountant is the registered agent for service of process only. I get into this situation a lot. I have a lot of clients who are forming Connecticut LLCs, but they are not Connecticut residents, so they cannot be the registered agent. So I act as their registered agent. The fact that I'm acting as their registered agent does not make me a company applicant unless I am also the person who signed the certificate of incorporation or the articles of organization for an LLC. Hopefully that is clear. So example, Mo, Larry, and Curly form an LLC, 1/3 each. Mo is a retired attorney and he files the LLC paperwork with the state. He signs as incorporator or organizer. Mo, Larry, and Curly are all beneficial owners. They have to be disclosed, and Mo would also have to be disclosed as the company applicant. Okay, so hopefully that makes that clear. So, but the good news is this only applies to companies that were formed after January 1. Older companies, I mean, let's face it, if you've been in business for 30 years, you probably don't remember who incorporated your company. And the government doesn't ask for that. They don't want that information. They only want this for newly formed companies. Must make this clear. Okay, if you form the company without assistance and you are the sole beneficial owner of the company, let's say you have a one-person LLC, you did it yourself. You went online to the Secretary of State's website and you did it yourself. It is not clear whether or not you must also register as a company applicant. This is one of the gaps in the statute, one of the holes in the statute that we don't know yet. Your disclosure as beneficial owner should be sufficient. Unless, of course, you do not qualify as a beneficial owner, you own less than 25%. So in which case you should disclose. That's the situation in my example with Mo, the retired attorney. He doesn't own, he owns 1/3 of the company, but let's say he owned only 10% of the company. It doesn't matter. He is not a beneficial owner, but he would have to register as a company applicant, because he was the one who actually filed the LLC or corporate paperwork. What if you form the company using LegalZoom or one of the other online services here? You're going to have to contact them and find out who should be reported as the company applicant. Now, as I understand LegalZoom, mostly you're the one who signs all the documents. So if that's the case, you are probably the company applicant in that case. But LegalZoom is a company. It cannot itself be a company applicant. Remember, The whole purpose of the act is to track down individuals who are responsible for a company's existence, not other companies. So if you use LegalZoom to form your company, and LegalZoom had Joe Blow sign the incorporation paperwork, one of their gazillion in-house staff attorneys, then Joe Blow is the company applicant who has to be disclosed, not LegalZoom. And you have to call up LegalZoom and find out who that person was. Because I'm sure at some point LegalZoom and all the other online filing services are going to build this into their service so that you won't even have to think about this anymore. They will determine who the company applicant is and make sure that that person is properly disclosed. But again, right now, if you formed a company using LegalZoom in January and that March 31st deadline is creeping up on you, you're going to have to find out who that person was, or else you may not be filing a correct BOI. Also, the good news is no more than 2 company applicants need to be disclosed. So if you're one of those people, and I've dealt with them before, they file a certificate of incorporation and there's 4 people listed as incorporators. Pick the 2 that you want to be disclosed as company applicant and just disclose those. Although if they're all equal shareholders, they would still have to be disclosed as beneficial owners. The company applicant thing is the most complicated part of the act. The good news, it only applies to companies that were formed after January 1. And in most cases, the person will be easily identifiable. The one difficult thing the LegalZoom example, where you have to actually, or it might not be LegalZoom. Let's say you use one of the registered agent services like CT Corporation or Cogency Global or one of these places, US Corporation Agents or something. That's when you would have to track down the individual employee of that company who has to be disclosed as a company applicant. Okay, so now you've filed your BOI. If you were formed after January 1, you did it during the 90 days, or if you were formed earlier, you did it before January 1 of next year. Now what do? Are there ongoing requirements? Well, here's the good news first. You don't have to do this annually. This is not like an annual report with the Secretary of State you have to do a new one every year. Once you file this sucker, you're basically done, okay, until the information changes. So for example, you get a new driver's license with a different number. You roll
It's Bob Hogan. It looks like Cliff is frozen. We're gonna try and get him back here as soon as possible. Thanks. Hello, everyone. It's Bob Hogan. Just stand by. We're just trying to get Cliff back on. Hello, everyone. It's Bob Hogan. We're just Cliff is just joining again, and we should be going in momentarily here. Cliff, if you can unmute, we are all set. Okay.
Okay.
The joys of the internet. Cliff's internet connection got severed, but we will pick it up from. Maybe you just back up a little bit, Cliff, because you did freeze near the end there.
Okay. First of all, hoping everyone can hear me. I'm not able to do video right now because it's saying that the host has stopped it, but that's okay.
Uh, Cliff, are you there? Cliff, we can't hear you. Hmm. Okay, ladies and gentlemen, Cliff is just rejoining again. Sorry, we're having an internet problem at his end, but he should be here momentarily. Okay, Cliff, I think you're back. If you could unmute. And
There
we're
we
back. There
are.
we go.
And we are back. So we're going to share. All right. So what I'm going to do, Bob, at this point is I'm going to give you a countdown. Okay. So you can splice, you're going to have to splice out this gap here. So let's just do that.
Okay.
And then, so 5, 4, 3, 2, 1.
Okay.
Okay, so let's talk about what happens after you disclose. So you filed your BOI now. Hopefully everybody is recorded properly. What do you have to do to keep this thing alive? The good news is there's no annual report requirement. This is not like, filing an annual report with the Secretary of State where you have to file every, report every year. Once you file this sucker, you're basically done with it until the information changes. And then you must update, you have to remember to update your FinCEN registration within 30 days of the date that you actually became aware of the change. So if you change your mailing address, you move, well, your company's going to have to move with you, but you're also going to have to remember to update your FinCEN registration with the new mailing address. What about your driver's license? Your driver's license expires, you go to DMV, you get a new one. You have basically 30 days to update your filing with a photo of the new driver's license, because it probably will have a different number than the old driver's license did. Your US passport, same thing when the passport comes up for renewal. So all of this has to be updated. This, to me, is the biggest trap of the Corporate Transparency Act. Filing the initial report is really all not that hard. It's not too burdensome on you, but remembering that you have to do this each time a piece of that information changes. I just can see a lot of people who are not going to be able to comply with this requirement. I'll be very frank about it. This to me is the most dangerous part of the Corporate Transparency Act, not the initial filing, but the ongoing keeping this thing up to date. They are relying on you to remember to go, or your attorney or accountant remember that every time a change is made, you have to update your FinCEN information. And it's got to be done within that 30-day requirement, or else the same penalties apply as if you were late with the initial report. This is something, if I had one thing I wish they would change, it's this. Because it's going to be very difficult. What's going to be happening is that they're going to be relying on the accountants and lawyers who are filing these things to keep their clients awake about stuff like this. And in my case, I've got a couple of thousand companies that I've formed in the course of my career. It's going to be very burdensome on me to send out notices saying, hey, by the way, has any of the following information changed? If it has, you have to update your FinCEN. Okay, so that brings us to my favorite topic. What happens if you don't comply? What happens if you blow it or you blow it off? Not recommended. The penalties are very, very steep. There are civil penalties of up to $500 for each day the BOI is filed late. There are also criminal penalties, which include imprisonment for up to 2 years and a maximum fine of up to $10,000. This is there is a lot of bad information on the internet about this. I have seen some websites from otherwise reputable people saying that the civil penalties are capped at $10,000, and that is not correct. It's the criminal penalty that is capped at $10,000. So if you are 100 days late filing your initial BOI, 500 times 100 is $50,000 that you now owe the federal government. And maybe they will forgive that if it was an honest mistake, but you cannot be sure about this with the federal government. Also, an individual who willfully causes an entity not to file a required BOI report may also be subject to civil and criminal penalties. Do not expect your attorney or accountant to say, don't worry about it. It's a stupid thing. It's one of those government things. It's very intrusive. MAGA. I don't want to. You shouldn't have to do this. Don't listen to that. That is not very good advice, and that person is going to be subjecting themselves to a world of hurt if if you do not file the thing. So again, the big question is, and a lot of you are asking this question, and I wish I had a better answer for you than I do, is how does FinCEN plan to police compliance? How are they going to know that you didn't do any of this that you should have done? It's they're not asking for the kind of information that's going to make it easy for to police. Now, sooner or later they will access all the Secretary of State's records. Sooner or later, I mean, if I were one of the registered agent services like U.S. corporation agents or Cogency Global or one of the places, I would be all over this, because I mean I have liability too. I know all the companies that I have formed since the beginning of time. So I'm in a better position than most people to send reminders, people saying, hey, you have to do this, you have to do this, you have to do this. That's what they're going to probably do, is they're going to go through the intermediaries, the attorneys, the accountants, I mean, they can go on the Secretary of State's database in any state in the union and get a list of every corporation and LLC that's still on active status. And that will have the date of formation and all that other stuff. Will they be taking the time to do this anytime soon? I do not know. Obviously, as an attorney or an accountant, as an attorney and a tax preparer, I do have a PTIN number with the IRS. I cannot advise any client to just ignore something like this. It is something that has to be done, and I cannot offer any better advice than that. Okay. We have a little now, as that wasn't complicated enough. So that's basically it on the the federal Corporate Transparency Act. But to show you what a great part of the country we live in, New York decided last year that they thought that the Corporate Transparency Act was such a great idea. They said, hey, we need to have a Transparency Act of our own. So last year, the New York legislature passed something called the LLC Transparency Act. It was passed by the legislature in the fall of last year. It wasn't signed by the governor until March of this year, and for the basic reason that unlike the federal statute, the New York statute, as it was originally drafted, was going to be a public database. The legislators wanted this information to be accessible to any individual who asks for it. So if you, under the original version of the act, if you are looking at a New York LLC or corporation on the New York Department of State database, you could get information about the date of birth of the owners, copy of their driver's license, and the governor did not like that. The governor, I think, very wisely got that provision knocked out of the act, the final act that was passed in New York. So the version of the act that the governor did sign on March 1 of this year does not require public disclosure of the information. The information will only be available to law enforcement agencies, the same as the federal statute. Okay, so that's the good news. And the good news is the New York statute, first of all, it only applies to LLCs. It does not apply to corporations or to any other entity. It only applies to LLCs, and it doesn't take effect until January 1 of 2026, which means we are all going to forget about this for 2 years until I do the follow-up seminar for SCORE, which I probably will do on the New York Act when and companies will have until January 1, 2027 to file their report. So they successfully kicked this can very far down the road. It applies to domestic LLCs, foreign LLCs doing business. The same exemptions, they basically copied the federal statute. So it's the same exemptions, the same information will be required. Newly formed LLCs will have to register upon formation or registration, though. There's no 90-day window. They figure, hey, we're giving you until 2027 to comply. You can comply at that point. You don't need another 90 days on top of that, so that's the New York statute. You can basically forget about that for now, but keep it in the back of your mind because more states are going to be jumping on this bandwagon. Now they're going to say, hey, we'd love to have a database of all the owners of LLCs and corporations in our state. So watch for the pylon now because it's probably going to happen. Okay, so after all this program, you should have enough information that you could probably do a BOI yourself. But what if you still need help complying? Most lawyers and accountants who regularly form small business entities probably will handle your FinCEN registration for a reasonable fee if you are an existing client. So for example, right now, I mean, I am doing FinCEN registrations, and you can just use this for general guidance. My fee currently for a new client, somebody that I've never worked with before, is $250. It's a flat fee. You pay me once and that's it. I take care of it for you. If you are an existing client, it's $100. I have over a couple of thousand companies that I've formed over the years, and I don't think it's fair to charge them the same rate that I would a total stranger. I know them after all. I don't have to do any diligence on their operations. I don't have to. I mean, if you're a new client and you come to me and say, "Hey, Cliff, you don't know me. I'm Joe Blow, but I really am nervous about this FinCEN thing. I want it done properly. I want you to do it for me." That's great, but I'm going to ask you a gazillion questions, and I'm going to ask you to sign an affidavit under penalty of perjury saying all the information that you are giving me is accurate, because I have no way of knowing otherwise, what this information is. And if you're dealing with another accountant or lawyer, you should expect that they will have the same thing. If you have not worked for that lawyer or accountant before, however, be prepared for them. They're going to do diligence on your company to ensure that the filing is accurate. They are personally liable. If I submit a filing to FinCEN that's not accurate, I am personally liable for that. And that's not a risk I am about to take lightly. Most registered agent services will probably offer a FinCEN registration solution for their clients. I'm seeing a couple of things online, but not from any one of the major registered agent services. But if I were them, frankly, I'd be foolish not to get into this business because they already have the information, except for the driver's licenses and the passports. They have all the information on file necessary to do the filing, and it's going to be a major income generator for them. So they're foolish if they don't do it. Okay, if you're looking for more information, the FinCEN very helpfully did publish a small entity compliance guide, and that's the link where you can find it online. These last two websites, these are services that have just recently been formed to help people with their FinCEN filing. FinCEN Fetch, I do not believe will help you with your filing. What they're doing is they provide a software solution that you subscribe to on a SaaS basis that will help you comply with FinCEN, but they don't do the actual filing for you. You have to do it as a software solution. It's a SaaS download. Transparent Filings is more of a service that will actually do the filing for you for a significant fee if you don't have an accountant or lawyer. I think you're going to be seeing more of these cropping up, but these are startups. These are not companies that have been in existence for years. So buyer beware. So here are the key points. I think we're at the point of summation. All corporations, LLCs, limited partnerships, LLPs, any company that had to file with the Secretary of State when they were formed, regardless of size, must file their beneficial ownership report with FinCEN sometime this year. Beneficial owners are those individuals, not companies, that either substantially control the company's business or own 25% or more of the company, or both. Companies formed after January 1 must file within 90 days of formation, and they also must include information about company applicants, the people who actually were responsible for filing the incorporation paperwork. And then New York has its own version of the law applicable only to LLCs that goes into effect on January 1 of 2026. So those are the key points. Here's some information about some of the books that I've done. Here's the information about me. So if you do want to reach out to me, I mean, I'm more than happy to work with any score client. That's it. But just be aware there's going to be a fee involved. Unfortunately, there's a lot of personal liability involved with this, and it's not something that attorneys and accountants are going to take on lightly. So Bob, why don't we I'll pass the ball over to you, and let's take a couple of questions. Because of the technical hiccup, I'm happy to go a couple, few more
Yeah,
minutes.
like I say, given that we lost a few minutes, we will run over here and take a few questions. So if there were a number of questions early on, which I think you've clarified about, if you have an LLC, you have to file. If you have a sole proprietorship and you have not filed anything, you don't have to file. So I think we can skip over those. There was one here that from Jesus. I have an LLC that doesn't even have a bank account yet, but I'm not a U.S. citizen. Does the requirement apply?
The answer is yes. If the LLC was formed already, the fact that you don't have a bank account doesn't make any difference at all. You are required to file, and if you don't have an EIN as yet, you really should push to get one, because that is part of the compliance requirement. The good news is, if you form the LLC before January 1, you have a whole year. You have until December 31st of this year to file your initial BOI. So you have some time, but you are going to have to get an EIN, and that may require you as a foreign person to get an ITIN, an ITIN. Since you probably don't have a social security number, you're going to have to file Form W-7 with the IRS, and it may take a month or so for you to get the information that you would need to get an EIN for your company. They don't require that you have a bank account, but they do require that you have an EIN from the IRS. So that's the key thing that you need to focus on, Jesus, right now. Yeah, go ahead.
I say very, very helpful. There's here's one from Judith along the same lines. I registered last year, I assume an LLC, but I did not make any sales. Do I need to do taxes? I think that's off the point, but it's maybe we answer it. Do you have to file?
A little beyond, but I will always answer the question. Okay,
Yeah.
you formed an LLC last year. You didn't do any business. The answer is yes. You're really supposed to file Schedule C on your tax return. So if you're on extension till October, which virtually everybody does these days, nobody files on April 15th anymore. Make sure that your accountant knows you have to do a Schedule C for the LLC as part of your 2023 tax return. If you already filed your 2023 taxes, you should ask your accountant whether it's worthwhile to do an amendment to your return to add a Schedule C to it. Your accountant probably will say no, but let them make that determination. I don't know you, they do. As far as the FinCEN is concerned, though, yes, you have to do your initial BOI before December 31st of this year. That's the easy question.
Yeah, perfect. Here's one from Kay, which I'm not sure you can answer, but maybe you have an opinion. Due to fraud and hacks, is the site secure enough to place our home address, or shall we just buy an outside address to be safe? Your thoughts on that?
Let's put it this way. This is a very good question. No site is perfectly safe from hacks. If the North Koreans want access to something badly enough, they can get it badly enough. And that's just part of the world that we live in. And the short answer to your question is, I mean, is the site secure enough? Well, it's the federal government, but then I'm reading things in the Wall Street Journal every day about hacks into the Department of Defense and stuff like that. So I mean, if you're really nervous about this, I mean, I've been saying this for years, by the way, if you have a business, especially, and you work out of your home, you should seriously consider getting a UPS store private mailbox address. A lot of people don't know this. The UPS store is the place where you go to mail your UPS packages, also offers a private mailbox service where you can get an actual street address for your business. So for example, my 2490 BlackRock Turnpike address that you'll see on all my emails and other correspondence is a UPS store in Fairfield. I don't give out my home address, and neither should you. So if this is something that's gonna worry you a bit, get a UPS store. They will not accept a PO box. FinCEN will not take a PO box, but they will take a UPS store private address as the mailing address of the business. So that's a solution. If you're really concerned about security, that is a solution that you should look into.
We'll take one here from Shaw. What if starting out you're the sole owner of your LLC and a few years later you have added a partner or investors? Do you just update your info on this form?
Yes, the answer is correct. You would update your information. You'd have to do it within 30 days of the day that they come on board, either the first day of their employment or the date that they actually acquired stock in your company. You have 30 days to do that.
Okay, perfect. We'll take one more here and then we'll wind it up. Here's one from Harry. Do I need to include LegalZoom if they created my LLC as the company applicant? They are also my registered agent. I also have an office space, so do they need to be included?
Okay, this is what we talked about before. If you use LegalZoom or another registered agent service to form your company, you have to find out who you need to name as the company applicant. You cannot name LegalZoom or CT Corporation. You have to find out who the actual person was who filed your paperwork, and that's the person whose information needs to be disclosed as the company applicant. You're going to have to find out who that person was. Call your if you're working with LegalZoom, you probably have a customer service rep or somebody there, and I would begin the inquiry there, saying, "Hey, I'm looking to file my FinCEN thing, and I just don't know who is the company applicant. How do you want me to do that?" And just follow their instructions, whatever they tell you to do.
That's great. We're pretty much running at about 10 past the hour, so we're going to wind it up there. That's all the time we have for questions. Just as a reminder, the webinar has been recorded. I know there's going to be a little interruption in the middle, but it's all there. And the materials will be available on our website within the next day or so. And again, if you want to access the on-demand webinar, you just go and use the link that we showed earlier on the screen, or you can just click on demand. Our next webinar is tomorrow, March 27th at noon. The topic is positioning your business for government contracting with Tanisha Baptiste and Shelley Rose presenting. Again, more specifics on our website. And if you'd like to access the mentoring, again, you can just use the yellow link on the screen. And on behalf of everyone, I'd like to thank you all for attending. Sorry about the technical difficulties. And Cliff, big thank you to you. Lots of great information here. And have a
Well,
great
thanks,
day.
and good luck to all of you. And please do not name me as your company applicant without my consent, please. You do not want to know who my lawyers are, and you definitely do not want to meet my cousin Vito. Okay, please don't do that.
Thanks, Cliff.
Okay,
Take
take
care.
care. Bye bye.
All right, bye-bye.